The special counsel regulation provides a procedure for appointing a special counsel. Okay, but you don't have the authority because this is gone. And the Constitution says that you can only make those appointments as they're dictated by law.
In this brief, the thing that I was really looking for was an argument that Judge Cannon should be removed or recused from the case. I don't see that yet in the 81 pages that you just mentioned.
Nope.
But of course, we just got this a moment ago, and it will take I and others some time to parse through it.
I invite you to join me in doing all that we can to save our country and elect President Donald J. Trump and send him back to the White House to do the tough work of saving our country and serving the people. Thank you very much. Thank you very much, Mr. President.
Jack Smith, the illegitimate so-called prosecutor who got laughed out of court for being illegally appointed by Judge Eileen Cannon in Florida in the classified documents case, is back. We thought, oh, he'd learned his lesson. He's not a real boy at all, but he has decided he's going to fight for it. He's taking this classified documents case, which has now been dismissed, up to the 11th Circuit. You can see we're in the Court of Appeals here today. And it is the case of Trump versus the United States, or vice versa, rather. They're prosecuting him. Trump is now, he's successful in this case. The case has been dismissed because Jack Smith was illegally appointed. He's not a U.S. attorney. He was not appointed by President Biden. He was not confirmed by the U.S. Senate. And what has happened here is they've cobbled together, historically speaking, a bunch of other statutes that they used as justification to give them power to basically do whatever the hell they want. And so Jack Smith came, misappropriated tens of millions of dollars, 24 million, I think was the tally at the last count, against President Trump. They raided his house. They took pictures of Melania's bedroom. There were no classified documents in her underwear drawer, but they went in there, at least into the bedroom. Don't know if they actually opened that drawer, but we're talking about the FBI, so probably. But now Jack Smith is upset. His case has been dismissed. The individual who was signing off on this via Jack Smith is James Pierce. So here is what he says. All right, 11th Circuit, I am a real boy. Accept me. He says, all right, listen, Congress, this is Jack, has bestowed on the Attorney General, which would be Merrick Garland in this case, the guy who appointed him, like the heads of many executive departments, broad authority to structure the agency he leads to carry out his duties. 2 statutes give Garland the authority to appoint people like me. U.S. Code 515B 5331. Now, what's so interesting about these, as we poke around here, 515B, we're looking at the Attorney General and FBI subsections here. So 28 U.S. Code, there's a bunch of chapters inside of it. We're looking here, we've zoomed in on this section, the Attorney General. So when we go back to the motion, 515B and 5331. So 5331, you'll see is right here, 531, all the way up to 540D, right? These are the sections, the subsections that we're in. So that means that they're relying on, with 533.1, a subsection right in the FBI. That's not the Attorney General. So they're relying on 533 right here, investigative. This is the FBI section. They're going to rely on this, that the Attorney General may appoint officials with the FBI, or in the FBI section, to conduct other investigations regarding official matters under the control of the DOJ and the Attorney General. It's an official. They're going to say this plus that other statute, even though this is not within their purview, right? We're talking about other officials who might come in and give them expertise on something, not other U.S. attorneys to go prosecute whoever they want, however they want, whenever they want. My point is, they're cobbling together a bunch of statutes. Take a look. They're also going to point us to 509 and to 510. And when we go back to these statutes, you'll see 509 and 510 and all these different statutes are all talking about the functions of the Attorney General and the delegation of authority of the Attorney General and the Attorney General to advise the president and do all the things. But nothing in here says the ability to appoint a special counsel. They're just cobbling it together by referencing a bunch of different things. So just think of it, we're going to make a cake by sprinkling in all these different ingredients, right? 509, 510, 515, 533, and all these ingredients are from different subsections. But the problem is you can't do that. You just need something that is a cake, right? You can't make it up from all of this other stuff. So precedent and history confirm those authorities, they say. So we've already done this before and nobody was upset with us. And historically speaking, we've done it, many times. There's a long history of this, a long tradition of special counsel appointments by AGs. And this is true, by the way, right? There is true. Like nobody's really made this argument before. Kind of came up in a prior case called Nixon, but many people would argue that was dicta, which means it's not actually relevant to the holding of the case, which means it kind of doesn't count. The district court's contrary views, this is Judge Cannon, conflicts with an unbroken course of decisions, including by the Supreme Court, which is is debatable, that the Attorney General has this authority and is at odds, so Cannon is at odds, with long-standing appointment practices. Now, this court should reverse the 11th Circuit. Now, here are the questions that the 11th Circuit needs to grapple with. Question 1, whether Merrick Garland had the authority by the statutes, by the law, to appoint Jack Smith in a way that was in alignment with the Constitution. Because, as we know, the president makes the appointment and the Senate confirms. And whether the statutes that Merrick Garland invoked, which are many of them, to appoint Jack Smith, constitute other law, which means that they have this other provision, so they can just appoint whomever they want. Now, such that using that source of funding for the special counsel was consistent and that Jack Smith didn't steal the money. So here's the background on this case. Now, we're familiar with this. We'll fly through it. But remember, when we rewind the clock on this, a grand jury in Florida returned an indictment that charged Trump with classified docs charges. Now, the grand jury was illegally impaneled, so he skipped that part because Merrick Garland appointed you already. Then what we know is they charged other people with crimes, and there was a dismissal of the case. Thanks for the procedural history there, Jack. You didn't talk about your appointment a whole lot in there. Notice that? We'll see if he gets to it. But he didn't talk about Trump's announcement of running, the date of that, when Jack got appointed, the date of that, how Merrick Garland appointed that. We'll see if it comes up, but pretty light on those facts. So here's the legal background. Now, the Appointments Clause provides that officers of the United States shall be appointed by the president. See that shall word? It means it's not discretionary. It must be done with the advice and the consent of the Senate. That's in the Constitution. But Congress may, by law, right, they can pass statutes, which would be the U.S. Code that we're talking about, by law, vest the appointment of other officers as they think proper in the president alone, in the courts of law, or in the heads of the department. So Congress then, by statute, can say that Merrick Garland can appoint certain people. So Congress has told us, this is Jack Smith writing, that Attorney General shall be the head of the DOJ and be appointed by the president with the advice and the consent of the Senate. Section 503, very clear. No one's questioning that. Congress has, with 3 limited exceptions not relevant here, vested, they say, in the Attorney General all functions of the DOJ, including the power to prosecute all crimes and to supervise the conduct of the litigation and to authorize other officers to perform those functions. In fact, they say, in addition, Congress has also given Merrick Garland, the Attorney General, the power to commission attorneys, right? This is where they're going to jump in here, that are specially retained under authority of the DOJ as special assistants to the attorney. And they're referencing 515A and B. Now, Congress has further provided that they may appoint officials to detect and prosecute crimes. This is 533, right? So this is in the FBI subsection, and this is in the DOJ subsection. So when we go to 515, these are authorities for legal proceedings. So the Attorney General, this is where they say their authority is, the Attorney General or any other officer of the DOJ or any attorney specially appointed by the Attorney General may, when directed, conduct any kind of legal proceeding which they're authorized by law to conduct. Okay, so they're just saying this person right here. Wait a minute, this law says that we can have attorneys who are special. Wow. And they shall take the oath. And so that gives us the power to do this. Foreign counsel employed in special cases not required to take the oath, but the Attorney General shall fix the salary of a special assistant or special attorney. Right? And so often we're thinking of these like as expert liaison attorneys, somebody who's an expert in tribal law to come in and help us with tribal law, someone who's in private practice about whatever, pick one. And then they come in and they help. They support the main U.S. attorney who is still the actual U.S. attorney. So you can see their argument continues. Now, in 1999, the Attorney General issued a regulation. This is not a statute. This is not a law. This was not passed by Congress. This was passed by the Attorney General. Issued a regulation from the executive branch. We have a separation of powers problem here. Providing an internal framework for certain special counsel appointments. She created these regs. Now, the special counsel regulation replaced the independent counsel regime, which had already been established by U.S. code. So watch this little magical switcheroo that our crap government does all the time. And they admit it here. This is the prosecutor admitting this. Oh yeah, we had something called U.S. code, sections 591 through 599, title 28, right there. And then when Congress didn't renew those, what did they do? They just made up their own out of their booties. 28 Code of Federal Regulations, 600.1 to 600.10. Oh, good. We got the same exact statutes. Congress deleted them, and then some bureaucratic hack, in this case called Janet Reno, then took these and shoved them into the Code of Federal Regulations and just say, we're going to take those powers that Congress now expired, so we don't have those anymore, and we're just going to say we have them now. The special counsel regulation provides a procedure for appointing a special counsel. Okay, but you don't have the authority because this is gone. And the Constitution says that you can only make those appointments as they're dictated by law, but this is gone now. And so the DOJ did is they gave themselves their own power. The regulation provides a procedure for appointing a special counsel. Oh, well, Congress deleted it, so I guess we'll give ourselves the procedure now. Within within the context of the established procedures of the department. The regulation seeks to strike a balance between the independence and the accountability in certain sensitive investigations. Okay, no one cares. You didn't have the authority to create that. Congress gave you power in the U.S. Code right here, and then you have had that deleted because the regulation replaced it because it was gone. It's illegal. Now, the Appropriations Clause provides that no money, so he stole his position and he stole Jack Smith a ton of money, no money shall be drawn from the Treasury, but otherwise in consequence of appropriations made by law, right? You can't get a check unless the law, the code, the statutes passed by Congress, unless they give you that power, that right to draw upon those funds. The clause requires no more than a law that authorizes the disbursement of the specified funds for identified purposes. And they say, well, look, our useless government says in 1987, Jack Smith from the DOJ, he's like, look, we've got a slush fund. I can take all the money we want. In 1987, Congress passed a, quote, permanent indefinite appropriation. Do you know what that means? You can translate that. That's government thievery, bureaucratic babble. It's called a slush fund, an endless slush fund to, quote, pay all necessary expenses of investigations and prosecutions by independent counsel appointed pursuant to the provisions of the U.S. Code. Okay, Congress passed a law, a portion of the U.S. Code for independent prosecutors. The Independent Prosecutor Council statutes don't exist anymore. Jack Smith stole that money. He's not an independent counsel. So then on November 18th, Merrick Garland appointed John L. Smith. Okay, that's Jack Smith. His real name's John. He uses the name Jack because he's pretending with his real name too. I know it's a common moniker, but I mean, just use John if you're proud of that. You're not a real prosecutor and you're not a real Jack, John. Nice try. Pathetic. Just be yourself, man. You're not a real prosecutor. Go back to the International Criminal Court. You've got no power here. Stop stealing our money and prosecuting our president. John Smith as special counsel. Garland appointed him November 18th. Now we'll get into some procedure to conduct the ongoing investigation reference described in the motion for judicial oversight, right? So remember, Trump had the warrant. They executed the warrant, raided his house on August 8th. Then Trump filed this response saying, you guys have been totally corrupt. In the raid, he wanted a motion for judicial oversight. That's when we had the special master come in, get appointed, and provide oversight over this case. All the lefties cried, I can't believe that they're questioning the dignity of the DOJ. Now, the Attorney General, Merrick Garland, also authorized Jack to conduct an ongoing investigation into January 6th. Also illegal. Shouldn't have never been appointed there either. Relying on the authority vested in the Attorney General, this is what Garland used, okay? These four subsections, 509, 510, 515, and 533. So we've got 509, 510, 515. So 509 is going to be here, the functions of the Attorney General. And they basically just say that he can do kind of anything he wants, right? All functions and all functions of the agencies are vested in him. So he can do a bunch of stuff, right? That's 509. Then we go back, then we look at 510, delegation of authority. The Attorney General may from time to time make provisions and delegate other authority. And so they're cobbling that one together. Then we go over to 515, which I think we saw earlier. 515 says he's got other powers. And then we jump into the FBI subsection. Okay, so 515 is here saying he's got authority now to basically smash everything together. Each attorney, these are special attorneys now who can come in as special assistants, which are generally, they're not U.S. attorneys or special counsels. This is a statute that is governing something different, of course. And then what we see is 533, and that's the one in the FBI. So he's saying if we cobble all of those together, that gives us the power to create a Jack Smith. And says also, we've done this before, prior practice. Okay, we've already done this. And we've funded other special counsels, or in this case, like a special attorney. It's kind of the same. They're going to walk us through how they make their argument. But we've also been funded through this independent counsel slush fund because we're allowed to do that because there's a provision that says we have access to other stuff appointed under a law other than the now defunct Ethics in Government Act. So it's our money. We're fine. Trump moved to dismiss this. When we were in Judge Cannon's courtroom, Trump said, all right, motion to dismiss. Jack, you're not a real boy. Not at all. You violated your appointments clause. You're illegal and you stole a bunch of money. There is no statute in that entire list that we looked through that authorizes a special counsel, and the independent counsel is gone. There is no money that's available for you either. Now, Judge Cannon granted the motion. She dismissed this indictment. It was beautiful. The district court accepted for the purposes of its decision. They said that Jack Smith was an inferior officer. The special counsel was an inferior officer whose appointment Congress could vest by law in the U.S. Code. When we think of law, we think Congress passing U.S. Code. But in the district court's view, none of the four statutes cited by Judge Cannon or by Jack Smith in this case, because Merrick Garland appointed Jack Smith. So 509, it doesn't say special counsel. 510 doesn't say special counsel. 515 says special attorney for other things. And the 533 is for the FBI. So there is no special counsel that has all of the powers of a U.S. attorney who can prosecute anyone, anywhere, at any time with little oversight, if no oversight, or minimal oversight from the DOJ. Nothing, said Cannon, supports that. You can't just pick these out of your booty. Now, the district court also recognized that there was this Nixon case, that Congress, in those 4 statutes, had, quote, vested in the Attorney General the power to appoint subordinate officers, including a Watergate special prosecutor. But the district court dismissed that statement as non-binding and unpersuasive dicta, right? So they're saying it's not dicta. That's super important. You know, cases are very long and complex. We have these opinions that are hundreds of pages long, and sometimes the judges talk about other things that aren't essential to the holding of the case. They're saying that Cannon said, well, that was dicta, and so therefore it doesn't count. And so the appropriate remedy was dismissal, saying that Cannon said there was no statute that permits Jack to exist here, and they also found that he's not eligible to receive funding. Jack Smith stole tens of millions of dollars, and they didn't impose any remedy for that, but Jack Smith should pay all of that money back. The DOJ should pay it back. Here's the summary of Jack's argument. Now, the Attorney General, Merrick Garland, validly appointed Jack Smith, who's also properly funded. They say, unfortunately, in ruling otherwise, Cannon deviated from Supreme Court precedent, didn't understand the statutes, and didn't understand the long history of how this works. It says clearly, this is how it works. The Constitution says that Congress may give a head of a department like Merrick Garland the power to appoint an inferior officer. Here, they did that, and they can appoint a special counsel as an inferior officer who can do whatever he wants. Now, they say in Nixon, similarly, the Supreme Court had already determined that those 4 statutes and their authority to appoint a special prosecutor, which is a special prosecutor which is comparable to a special counsel. So it's very, very similar, they say. Now, every court has agreed, they say, saying that the Watergate prosecutors were fined and that Cannon made a mistake, that the Nixon case was dicta, saying that was an error. And they also made an error in assuming the Supreme Court decided that issue. They used qualifying language, and so she read too much into that. Now, the statutes before the Supreme Court in Nixon authorized the Attorney General to appoint a special counsel here. They did it in that case, and they can do it here. Why? Well, Section 515 consists of 2 subsections that, if you take it together, say that these special attorneys and special assistants are basically the same thing. Section 515B says that they can commission attorneys who are specially retained, and you can have them as special assistants, and they must take an oath. And Section 515A says that they may vest these specially appointed attorneys with power to take criminal proceedings. And so if you read that, that's basically like a special prosecutor. And so that's good enough. We can just make Jack Smith out of that one. Now, here is what Cannon said. They say Cannon was reading this wrong. Hello, Judge. Cannon was reading the word appoint. It says it focused on the absence of the word appoint in Section 515B, ignores that the term retain is basically the same thing as appoint, because an appointment is the same thing as a retention or something. As the statute's history makes clear, they say the word appoint appears in other parts. And also Cannon saying that the phrase specially retained is a past tense verb, which means that they're already retained attorneys. And they say, no, these are past participles, and we're not going to get into the grammar of all this, but they say your grammar is wrong, Cannon. And finally, the district court erroneously treated these 2 provisions, 519 and 543, as a limit, and that's not appropriate either. And so Congress authorizes this. By the way, they also authorized it in the FBI section. So if we go to 533, which is one section over, one kind of subsection down, Cannon says, I find that totally inapplicable. The district court found that this section is inapplicable on the theory that official means only non-officer employed. But official means officers, they say. So the power says under 533, you can appoint officials. And they say that's the same thing as officers. And so we can appoint officers. So they're just giving themselves a ton of power. And also, she is reading too much into the title. Okay. Yeah, so what if it's in the FBI section? We can still make an inference that it applies to us, the DOJ. And these sections 509 and 510 also grant the Attorney General broad power. So we can basically do whatever we want. Congress has given us full authority, and we can appoint these people. And we've done this for a long time also. From before the creation of the DOJ until the modern day, we've appointed special and independent counsels all the time. And Cannon disregarded this history. Now, the court's rationale could jeopardize the long-standing operation of the department. Oh, no. Yeah, this is great. And the decision could call into question hundreds of appointments throughout the executive branch. Yeah, you're all illegal. Get out. The DOJ is improperly funded. They say has properly funded the special counsel under our slush fund. And so Cannon has erroneously dismissed this case. We need our money and we deserve it. So here's their argument. Let's hit some of the highlights. It says, all right, as we know, Congress can vest the power in a department head. The only question here is whether Jack Smith was properly appointed. In Nixon, the Attorney General appointed a special prosecutor to investigate and prosecute the offenses from Watergate. In the Supreme Court, Nixon said that the case was not justiciable, right? There was no standing to bring this case because it was an intra-branch dispute. Supreme Court said, no, it's not an intra-branch dispute. And saying that the special prosecutor acted pursuant to a proper and legally binding delegation of the AG's authority and touches on some of these statutes. It also vested with him. And they say there, boom, that's it. Okay, that's what gives us the power. Saying Cannon erroneously determined that Nixon's reliance on that was only to subordinate officers and the special prosecutor was dicta. They say no, this actually mattered. If the Attorney General lacked the authority to appoint a special prosecutor, the regulation there would have had no force. And so they did settle this, so they think that it matters. So the court's determination was necessary, in coming to their determination. And so they're trying to really build up this Nixon case, which is a good case for them. Now let's continue on, saying even if the relevant language in Nixon were dicta, the district court was not entitled. So now they're saying, well, okay, maybe if it was, you still can't just set it aside because it was dicta. The court statement in Nixon was not subordinate clause and devoid of analysis. It was not prefatory. It should be treated as authoritative. And it's not, even if it were technically dictum, right? Because it had nothing to do with the underlying holding. And so in sum, the Cannon erred in failing to treat Nixon's conclusion as controlling. Nixon was binding, and Nixon is correct. They say 515 gives them power to appoint special attorneys like special counsels, special attorneys. They can commission people. All this is done under the DOJ, and they give us some other cases. They reference back to Marbury versus Madison. This is curious. Talking about commissions, and we know there was a big battle in that case over that. Now, the district court, however, read section 515 as nothing more than a logistics-oriented statute. It was a technical and procedural statute, and it applied to already retained and other special assistants already within the DOJ. Yeah, you don't get to shoehorn in an entire special counsel statute into that one provision. Cannon focused on the word retain rather than appoint. If you want to appoint a U.S. attorney, then you have to appoint them. You don't get to use the word retain. Specially retained. They walk us through some of the history. The history confirms that it was a statute granting power to appoint. In 1870, the DOJ was a direct precursor to Section 515B, 1870 Act that established the DOJ. The next subsection, 533, this is the FBI subsection, and they say this is very similar. It talks about officials, but what we're talking about are officers. So Jack is someone who can come in as an officer under the official statute of the FBI, provisions of the law. And they say that Cannon made a mistake by saying that this was in the FBI section. That can't limit this. It only can shed light on ambiguous things, but it's not ambiguous here. And these other two statutes saying that the DOJ has been vested into the power of the DOJ into one person, the AG. And the AG has broad powers to basically do whatever he wants. And so he can make changes as he considers appropriate under Section 510, and he's been doing this for a long time. He's got significant authority. The Supreme Court has said this. It follows that giving him broad authority to create these offices are reasonable. Cannon incorrectly interpreted this to other people, but this applies also to Jack Smith. The sections confirm that reading. He can perform any duty required of the office. Attorney generals have long relied on these, by the way, right? We've been doing this for a long time. The department currently consists of 23 disgusting offices, 8 sick divisions, 6 twisted bureaus, and 3 ugly boards. Wow, that's a lot. Although some of these organizational units, such as the National Security Division, were created by Congress, most were created by the AG, gross, including the Public Lands Division, the Criminal Divisions, and the Antitrust Division, the Tax Division. They just keep going. Civil Division, Executive Office, the Civil Rights Division, and so on and so forth. But Congress has repeatedly confirmed the lawfulness of this. Congress routinely enacts statutes premised on the lawful existence of all of this, and so Congress sometimes exercises its prerogatives. There have been some changes in the past, but Congress has given Merrick Garland a lot of power. For more than 150 years, AGs have appointed special counsels to investigate this. It's a deeply rooted tradition, and they're referencing a law review article from Brett Kavanaugh. That's funny. You know what else has been a tradition for over 150 years? Not prosecuting your political opponents in America. They wrecked that one. In 1857, the Attorney General appointed Edwin Stanton, and he investigated other claims. Yeah, we know it's happened a lot, but the way that you're claiming that your power exists is illegal. If there's been questions about doubts of authority about special counsels, Congress should have intervened, they say. If Congress was unhappy with this, they could have intervened. They regularly appoint special counsels from within and outside the departments. Special counsels got new prominence during Watergate. Section 509 and 510 were created. Then we had the independent counsels in the wake of Watergate. Then there was the Ethics in Government Act. Then they created the independent counsel and the special prosecutor. And then those all expired. It was a big problem. Following the act's passage, they continued to appoint special counsels. Later, then the constitutionality of the Ethics in Government Act went haywire, and they appointed a bunch of people to do more investigations. And Congress considered whether to allow that act to expire, and it did. Then they made their own rules. So Congress gave you a bunch of power, then it expired. After Congress let it expire, then the Attorney General created the regulations that currently govern themselves. And if they have that power, Congress should give it to them, right? Congress should pass a statute. Just make it very simple. They don't get to just create it. They made it Code of Federal Regulations. And the Attorney General at the time just pulled it out of their butts. Now, in the years since, Attorney Generals have continued to appoint special counsels, including many like Robert Hur, John Durham, and David Weiss, who were U.S. attorneys. John Durham was a U.S. attorney, Robert Hur was a U.S. attorney, and David Weiss were all U.S. attorneys. Jack Smith was not. Some from within the department and some brought into the department like Jack Smith, who was not appointed. That's the difference, losers. Point that out. In the district court's view, however, this history is nothing more than a spotty picture of an ad hoc, inconsistent practice. Now, to reach that conclusion, the district court attached undue weight to superficial variations in historical practice, saying that there were differences. Some people relied on certain sections, some others did not rely on those sections. But Cannon gave undue weight that some have been appointed from within the department, while others have been appointed from outside the departments, using this word retained. According to Cannon, Jack Smith is a private citizen exercising the full power of a U.S. attorney. But he is not a private citizen. He's a sworn officer of the DOJ, according to your swearing in, but there's nothing in the law that says that's appropriate under the powers that you're granting him. That's the point. There was a period in American history when private citizens, by the way, they say, prosecuted some of the most consequential cases of the day. But that has not been the practice for 150 years. And to the extent that they use the term private citizen to refer to someone who is not already a member of the DOJ before receiving his commission, the definition equally applies to every member of the department and has no relevance to the appointments clause or to the statutes authorizing his powers. Now, Cannon likewise attached undue weight to other independence granted to other special counsels. And so the independence of Jack Smith is really irrelevant. And there was also undue weight to the nomenclature, the naming conventions. Special attorney-like figures are different than special attorneys, or the difference between special prosecutors or independent counsels or special counsels or whatever. They say, shut up. It doesn't matter. Okay, any linguistic variation between these terms is entirely superficial. Whatever. We can call them whatever we want, and we can have them do anything that they want to do. Any subtle non-semantic difference is just semantics. It has no bearing on whether Congress gave us that power. We have the power, so just eat it. Now, the district court's reasoning also needlessly cast doubt on long-standing practices in the DOJ. Yeah, because they're corrupt. They should be cast out. It suggests that every special counsel throughout history who was appointed from outside the DOJ who did not assist a U.S. attorney was invalid. Yep, bingo. That every AG who made an appointment was acting ultra vires, outside the law. That Congress repeatedly overlooked a persistent pattern of errors, and that the Supreme Court itself failed to spot the flaw in Nixon. It wasn't before them. They weren't asked about it. If the Attorney General lacks the power to appoint them, the conclusion would invalidate the appointment of every member of the department who exercises significant authority and occupies a continued office, other than the few that are specially identified by statute. That's the point. If the law doesn't give you a seat, you're gone. Get out. The DOJ needs to be reined in. They did this ultra vires. There is no law that authorizes them to do this. The fact that Congress is weak and pathetic and that this has not come up before is irrelevant. That happens all the time. Provisions of the law, statutes are declared unconstitutional all the time. This is no different. Government cannot act outside of their dictated, delineated powers. At a minimum, that list includes high-ranking department positions like Deputy Solicitors General and Deputy Assistant Attorneys General. Get out. You're not lawful. You're as illegal as Jack Smith. You're not a real boy. The district court's rationale would likewise raise questions about hundreds of appointments throughout the executive branch, including the DOD, the state, the Treasury, labor. All of them are making up these statutes out of their derrieres. The implausibility of that outcome underscores why the district court's novel conclusions lack merit. I disagree. It's why it was epic, and we can't wait for it to be affirmed by the Supreme Court. They say Jack Smith also stole his money lawfully. He can steal whatever he wants. Congress gave us a permanent, indefinite appropriation. It was permanent and it was indefinite. indefinite. Okay, so it's ours permanently, indefinitely, our money. That's our government. And Congress is just like, okay, that's fine. Just please don't prosecute us. Okay, we'll give you all the money in the world. The district court's conclusion depended solely on its erroneous determination that no, quote, other law supported Jack's appointment. But these sections clearly give us the power to be here. And because Judge Cannon was wrong, so was its conclusion, her conclusion. So this court should reverse this dismissal of the classified documents case, bring this case back into Judge Cannon's courtroom, and tell her to put it back on the docket. Signed by James Pierce from Jack Smith's office. Now, he's not really even a real special counsel. There should be an asterisk here, Jack. Okay? You have been deemed to be invalid, illegitimate, and Judge Cannon is the one responsible for this. And so Jack Smith will be fighting for his survival from now into the future. And Trump, of course, will be responding to this in the 11th Circuit. We're excited to see what that looks like as our coverage here continues. Now, more on this. We've got some reaction from MSNBC. Here's what Lisa Rubin had to say after this dropped. Jack Smith scrambling for his very existence.
So Jack Smith has filed an appeal to get this case back on track. It's about 81 pages. What is the argument?
Well, Katie, the argument is exactly what we expected it to be, that essentially Judge Aileen Cannon ignored Supreme Court precedent when she found that the 4 statutes that Merrick Garland had invoked in order to appoint Jack Smith did not comport with the Constitution. And in doing so, she then found that under Article 1, Section 2, both the Appointments Clause and the Appropriations Clause, there was not constitutional authority for the Attorney General to appoint Jack Smith or any other special counsel because that person was operating sufficiently independently of the Department of Justice that they should be Senate confirmed. In this brief, the thing that I was really looking for was an argument that Judge Cannon should be removed or recused from the case. I don't see that yet in the 81 pages that you just mentioned.
Nope.
But of course, we just got this a moment ago, and it will take I and others some time to parse through it.
I'm going to be watching my email because I know we have a number of people here at NBC News and MSNBC reading through it. I want to read a little bit from it, and I'm going to ask you to translate it for me. The other provisions they cite, 28 U.S.C. and 509 and 510, they grant the Attorney General broad power, Jack Smith argues, to operate the Department of Justice. They also authorize him to appoint the special counsel in this case. Those provisions, first enacted as part of the law that created the Department of Justice, authorize the Attorney General to structure and staff the department in order to fulfill his law enforcement responsibilities. And attorneys general have long relied on sections 509 and 510 with Congress's full knowledge and approval to create the Justice Department's institutional infrastructure. And Congress has long used similar provisions to authorize other departments.
And by the way, those photos were fake also. Remember many of these were not even real. They just came and they shoved those on top of all these photos. And then they splayed all these out. And then I don't know what they were doing, but remember, there's some weird like cover-up stuff happening here. This is all just totally fake. And they tried to scare everybody with this. Let's see what she says.
Analogizing to other departments in the executive branch is a really interesting argument because essentially they're trying to say, if you undo this and you don't allow Merrick Garland, for example, to appoint special counsels,
you won't be able to raid your
reverberations not only across the Department of Justice, but across the entire executive branch where other secretaries rely on similarly worded statutes to appoint people who otherwise aren't Senate confirmed or appointed by a president to do the important work of the national government, Katie.
Oh no, the poor government is not going to have their bureaucrats. Why don't you put them through the proper procedure to hire them lawfully? You can't just make up departments out of your booty and then fill them with all your bureaucratic acolytes. There should be a process that is in comportment with the Constitution that enables checks and balances. That's why we have this, so that Congress can actually affirm these positions. Right now, they're just making them up. There is no oversight. That's why we have a weaponization of our government. And we have people who are very immoral who just decide, well, we're just going to prosecute our political opponents and shatter 200 plus years of historical precedents on this. Tulsi Gabbard came out and officially endorsed President Trump. The Unity Party vibes continue to increase all across the fruited plain of America and the world. Now, RFK Jr. is on the Trump train, baby. Choo choo. We also have Tulsi Gabbard on the train. Choo choo. It's going good, baby.
Because I am confident that his first task will be to do the work to walk us back from the brink of war. We cannot be prosperous unless we are at peace. And we can't live free as long as we have a government that is retaliating retaliating against its political opponents and undermining our civil liberties, weaponizing our very institutions against those they deem as a threat. Kamala Harris has done this over the last 3.5 years. She won't hesitate to continue that if she is elected as president. President Trump has been their first and foremost target in this because they don't want us as voters to even have the option to vote for him. I've been their most recent target, added to a secret domestic terror watch list after exposing the truth about what kind of dangers we would face if Kamala Harris is elected as president. We as Americans must stand together to reject this anti-freedom culture of political retaliation and abuse of power. We can't allow our country to be destroyed by politicians who will put their own power ahead of the interests of the American people, our freedom, and our future. I am proud to stand here before you today, whether you're a Democrat, a Republican, or an independent, if you love our country, as I do, if you cherish peace and freedom as we do. I invite you to join me in doing all that we can to save our country and elect President Donald J. Trump and send him back to the White House to do the tough work of saving our country and serving the people. Thank you very much. Thank you very much, Mr. President.
That's Tulsi. All right, so she's right and RFK's right, and I think what Tulsi brings is another person who can lend credibility to all of Trump's claims. The DOJ has been weaponized and rigged against him. All of the institutions that purport to bring us our democracy have all been weaponized to protect themselves against any external threats, Trump of which, of course, is the biggest. So Tulsi is now on the train. Happy to have her aboard. Welcome. We'll be keeping close eye on how this develops, obviously. We're excited for more people to come and join the party. But Merrick Garland is warning us, right? They've got control of the mound in the game of capture of the justice system. They've got it.
I guess as a follow-up on Scott's question, you're sitting in these hearings with prosecutors and judges at the courthouse down the street. They're increasingly expressing concerns about the upcoming transfer of power and the potential danger of another January 6th. Do you share those concerns at all?
I think our prosecutions have made clear what we think about people who try to interfere with the peaceful transfer of power, which is essential and fundamental element of our democracy. Quibble about whether we have 1,500 or slightly less than 1,500, but we have way more than 1,400 now prosecutions.
Wow, good for
we
you
have a
guys.
substantial number of convictions. I think that's shown to everybody how seriously we take an effort to interfere with the peaceful transfer of power. The last January 6th, the coming January 6th, and every January 6th after that. I want to make clear to anybody who's thinking about interfering with that, they can see what we've done with respect to the January 6th prosecutions, and the Justice Department will continue to protect our democracy.
Yeah, okay, except when it requires bringing the National Guard out, like Donald Trump suggested, and was rejected by Mayor Muriel Bowser that day. So we're going to be here continuing to cover this, my friends. Thank you for subscribing wherever it is you're watching this. Thanks for considering becoming a member, and for joining us back here on the next one.